Hey everyone! The Supreme Court just dropped a massive 6-3 emergency ruling late last night that's sending shockwaves through Washington and every state capital across America. This decision fundamentally reshapes the balance between federal power and state sovereignty, and the implications are staggering. Before we dive into what happened, make sure you hit that subscribe button and turn on notifications because this is the kind of major Supreme Court news you absolutely cannot afford to miss. Let me break down exactly what happened. The Supreme Court released a 6-3 emergency decision that directly challenges how federal courts have been operating for the past 20 years. The majority opinion makes crystal clear that lower court judges no longer have the authority to issue nationwide injunctions that freeze state laws across all 50 states when only a handful of plaintiffs are involved in the case. Now, this might sound like legal inside baseball, but the practical implications are enormous. Consider this. Over the last 10 years alone, there have been more than 60 nationwide injunctions issued by single federal judges. That means one person in a black robe effectively overrode the will of entire state legislatures, imposing their judicial interpretation on states that weren't even parties to the lawsuit. What the Supreme Court just did was slam the brakes on that practice. And the timing couldn't be more critical. Right now, we currently have 47 active cases across federal courts where states are seeking exactly these kinds of blanket injunctions. All of those cases just got thrown into chaos. The constitutional reasoning behind this decision goes way deeper than most legal analysts expected. Justice Gorsuch's concurring opinion cites historical evidence from 1789 through 1850, showing that federal courts in early America never once issued an injunction that applied beyond the specific parties standing before them. He references 12 separate founding-era cases where judges explicitly rejected requests for broader relief, even when plaintiffs argued it would be more efficient. This historical analysis matters tremendously because it suggests the entire practice of nationwide injunctions has zero constitutional foundation. Modern courts essentially invented it out of thin air. Justice Thomas went even further in his separate concurrence, pointing to Article 3 of the Constitution and arguing that federal judicial power is inherently limited to cases and controversies, which by definition means specific disputes between actual parties, not abstract policy disagreements affecting millions of people who aren't even in the courtroom. The dissenting justices tried to counter by citing civil rights cases from the 1960s, but the majority basically said those cases were wrongly decided on this specific procedural point. That's a bold statement with massive ramifications. Within 3 hours of this ruling being published, attorneys general from 12 different states issued emergency filings in their ongoing federal cases. Texas cited the decision in 3 separate lawsuits challenging federal immigration policy. Florida referenced it in 2 cases involving election law and social media regulations. Arizona invoked it in a border security dispute that's been tied up in the Ninth Circuit for 8 months. The speed of these responses tells you everything about how significant legal strategists view this shift. According to sources familiar with the matter, senior attorneys at the Department of Justice held an emergency conference call at 7 a.m. this morning to discuss how this affects their litigation strategy in 23 ongoing cases. The White House counsel's office is reportedly advising federal agencies to prepare for state laws they thought were blocked to suddenly start being enforced again, potentially as soon as next week in some jurisdictions. Republican governors are already announcing plans to move forward with enforcement of laws frozen by injunctions, while Democratic state attorneys general scramble to figure out how to protect their residents from what they view as harmful policies in neighboring states. This ruling completely rewrites the playbook for how legal battles get fought in federal court. For the past 20 years, advocacy groups on both sides of the political spectrum have used forum shopping, filing lawsuits in districts known to have sympathetic judges who will issue nationwide relief. The data on this is absolutely wild. Between 2017 and 2021, 78% of nationwide injunctions against federal policies were issued by judges in just 5 specific districts, even though those districts represent less than 4% of the U.S. population. The most extreme example was the Northern District of California, where 3 judges issued 19 nationwide injunctions in a 4-year period. That's more than the entire Fifth Circuit combined during the same time frame. Now that the Supreme Court has effectively killed this strategy, plaintiffs will need to file in multiple jurisdictions simultaneously if they want broad impact. That means litigation costs are about to explode. A case that previously required one filing in one friendly district might now require 15 or 20 filings across different circuits, each needing separate attorneys, separate arguments tailored to local precedent, and separate appeals. Major law firms are already sending memos to clients explaining that civil rights litigation, environmental challenges, and constitutional cases could now cost 5 to 10 times more than they did last month. Let's talk about what this means for actual policy enforcement on the ground. Immigration enforcement is the obvious flashpoint, with ICE currently operating under 14 different injunctions that limit various aspects of deportation policy, detention standards, and asylum processing. Under the new framework, many of those injunctions might only apply in specific districts, meaning federal immigration authorities could resume full enforcement in states not covered by those orders. Second Amendment cases are equally affected. Gun regulations in 6 states are currently frozen by nationwide preliminary injunctions that prevent enforcement, while appeals are pending. If those injunctions get narrowed to only protect the named plaintiffs, state officials could immediately begin enforcing firearm restrictions on everyone else, creating a situation where your Second Amendment rights effectively change the moment you cross a state border. Healthcare access represents another major pressure point, particularly around abortion medication, gender-affirming care, and religious exemptions to insurance mandates. There are 11 active cases where nationwide injunctions currently prevent state or federal enforcement. Environmental regulations are similarly tangled, with the EPA facing injunctions that block clean air rules, water protection standards, and climate-related regulations in ways that could now be limited to specific geographic areas, rather than applying coast to coast. Here's the fundamental question. If federal law can be enforced in Texas, but not California, or vice versa, based purely on where plaintiffs happen to file lawsuits, are we still operating as one country with one constitution? Or have we effectively created 50 separate legal systems? Election litigation is about to get incredibly complicated. Currently, there are 9 nationwide injunctions affecting various aspects of voter ID laws, mail-in ballot procedures, early voting requirements, and voter roll maintenance in 19 different states. Under the Supreme Court's new framework, those injunctions might only protect voters in the specific counties where plaintiffs live, meaning the same state law could be enforced in 80% of a state while being blocked in the other 20% based purely on where the lawsuit was filed. This creates an absolute nightmare scenario for election administrators who need to know months in advance what rules will govern their elections, so they can train poll workers, print ballots, and set up voting locations. The National Association of Secretaries of State issued a statement this afternoon expressing serious concern about the operational chaos this could create. Corporate America is quietly panicking about this decision. Companies that operate in multiple states suddenly face the prospect of navigating 50 different regulatory environments where federal rules might be enforced in some places, but not others, based on the geographic limits of various injunctions. The U.S. Chamber of Commerce estimates that compliance costs for multi-state businesses could increase by $47 billion annually if they need to maintain different operational standards in different jurisdictions based on which federal regulations are being blocked by limited injunctions in which districts. Banking regulations are particularly affected, with 3 major rules governing cryptocurrency, lending standards, and consumer protection currently frozen by nationwide injunctions that might soon only apply in specific circuits. Civil rights organizations are expressing deep concern that limiting injunctive relief could force victims of discrimination to fight the same battle in dozens of different courtrooms before achieving nationwide protection. The NAACP Legal Defense Fund pointed out that during the civil rights era, nationwide injunctions were crucial in implementing cases like Brown versus Board of Education. If those cases had been litigated under the new framework, desegregation might have taken decades longer, as each individual school district required separate litigation. What's really happening here Is the Supreme Court reasserting its own authority over the entire federal judiciary? By issuing this ruling through the emergency docket, rather than waiting for a full case with oral arguments, the court sent an unmistakable message that it expects lower courts to comply immediately. Statistical analysis shows the court has issued 47 emergency orders in the past 3 years that modified or vacated lower court decisions, compared to just 19 such orders in the previous 3-year period. This Supreme Court ruling changes everything about how federal power operates in America, and we're just seeing the beginning of the fallout. The implications for Second Amendment rights, immigration enforcement, election integrity, business regulations, and civil rights protections are enormous. Make sure you're subscribed and have notifications turned on because this story is going to develop rapidly. Drop a comment below with your thoughts on this decision. Does it properly restore constitutional limits on judicial power, or does it create chaos that will harm vulnerable populations? Thanks for watching, and I'll see you in the next update.